Although many people look upon alternative dispute resolution, or ADR, as a relatively recent invention, some ADR methods were being used in the Texas Territory long before Texas became a state. 200 years ago, when the Texas Territory was under Spanish rule, early pioneers and settlers used various non-judicial dispute resolution mechanisms with features quite similar to those in present-day arbitrations. When Mexico ruled the Texas Territory, the Queen of England successfully mediated a civil dispute involving a debt allegedly owed by the Mexican government to Texas. Despite these early efforts, ADR was not commonly used in Texas except in labor disputes and commercial transactions. Although Texas' first Constitution of 1845 generally mandated the enactment of laws, it was not until 1965 that the Texas legislature enacted a general arbitration statute that recognized the validity of agreements to arbitrate future disputes. The bench and bar were generally resistant to the use of arbitration and other ADR procedures. Thus, most Texas lawyers sought legal relief for their clients through traditional court procedures. However, during the years following World War II, the courts were starting to feel the impact of new litigation spawned by the many laws enacted during that post-war period. Within a space of several decades, the courts, particularly those in metropolitan regions, were overwhelmed by heavy case backlogs that prevented litigants from obtaining prompt and affordable judicial relief. In response to a strong public outcry, U.S. Supreme Court Chief Justice Warren Burger, at the now historic Roscoe Pound Conference of 1976, convened a prestigious group of lawyers, judges, court administrators, and law professors to consider how best to deal with this growing nationwide problem. During the Pound Conference, Harvard law professor Frank E.A. Sander offered a rather radical proposal to the Assembly. He suggested that the bench and bar adopt a multi-door courthouse approach to dispute resolution and that they develop an ADR system to fit the form to the fuss. One of the participants in that conference was a young court administrator from Iowa.
Significant events that regarding the evolution of ADR in Texas, I think, must start with the Pound Conference in St. Paul, Minnesota in 1976, in which Frank Sander delivered the multi-door courthouse speech that really gave impetus to the state bar and all other activities in all of the states, including Texas.
Another participant in the Pound Conference was Texas Supreme Court Chief Justice Joe Greenhill. Justice Greenhill took the message of the conference to heart, and in his 1979 State of the Judiciary message, he challenged the Texas bar and bench to consider the benefits of neighborhood justice centers.
Looking to a possible reduction in the dockets of trial courts as well as appellate courts, it occurred to me, and I'm sure to others, that one way was to get people to settle their disputes outside the court if they could.
The birth of the Texas ADR movement was a result of a serendipitous happening that involved Justice Joe Greenhill, who was in Houston attending a bar function, Charles R. Dunn, then president of the Houston Bar, and Judge Frank G. Evans, then a justice on Houston's First Court of Appeals. As Bob Dunn recalls Judge Evans,
said he had been talking to Judge Greenhill about something called alternative dispute resolution, mediations, arbitrations, things like that. And I had never heard of ADR before, but Frank explained that apparently Florida had begun a system to try to reduce the docket and the docket load on a lot of the Florida courts.
I think it was suggested, maybe I suggested it, that the Houston Bar have a committee to look into arbitration and mediation and alternate disputes resolutions.
Dunn immediately agreed to create such a committee if Evans would chair it. And before the idea could be discussed further, the Texas ADR movement had been born.
The first event, of course, that stands out in my mind is the birth of ADR, a birth that was presided over by Judge Frank Evans, but with the assistance of countless folks, primarily in Houston, but throughout the state.
Fortunately, the Houston Bar Association's new Neighborhood Justice Committee was comprised of a dedicated group of young and energetic lawyers. Within a 4-month period, Small teams of these lawyers traveled across the nation gathering information that would provide the design for Houston's first ADR center. In early 1980, the committee members submitted a written proposal to the HBA board, which voted unanimously to establish a neighborhood justice center in Houston. Although the Houston NJC was now official, there was much to be done before it could become operational. For one thing, it had no funding. Fortunately, Dunn and Evans had a close ally and friend, one Joe M. Green, then chair of the Board of Trustees of South Texas College of Law, and also president of the Rockwell Fund, a charitable foundation. Joe and Benny immediately saw the potential of a community-based mediation center, and with their help and the hard work of the Bar Committee, including the creative efforts of a young journalist named Lynn Liberato, the center was able to obtain the essential seed money to start its pilot program.
So what we did is we put together a script for a slideshow, and part of that script involved showing how a small dispute could escalate into a really large dispute.
By the end of September 1980, the Evans Committee had incorporated Neighborhood Justice as a nonprofit 501c3 corporation, hired an administrative staff, including its new assistant director, Kimberly Kovac, trained its first class of volunteer mediators, developed an agreement with the district attorney's office, assuring a steady source of referrals, and persuaded the Harris County Commissioner's Court to provide some surplus office space for the conduct of its mediation services. The Houston NJC's first mediation class was a proud group of dedicated volunteers. Included among them was one talented lawyer, the Honorable Margaret G. Mirabal, who would later become chair of the Houston Bar ADR Committee and a justice on Houston's First Court of Appeals. The Honorable James Wallace, then a justice on the First Court of Appeals and later a justice on the Texas Supreme Court, presided over the swearing-in ceremony.
That was kind of a momentous occasion. We had a swearing-in ceremony, and that was a sense of a revolution on the making. It was yet undefined, but there was a sense of revolution taking place.
In October 1980, the center officially opened its doors, and its volunteer mediators began mediating disputes referred by the district attorney's civil complaint desk. Because of the high quality of its mediators and the steady volume of case referrals, the center proved to be an immediate success. In 1981, State Bar President Franklin Jones of Marshall, Texas, created the State Bar's first Alternative Dispute Resolution Committee and named Evans as its chair, and Texas Supreme Court Justice Joe Greenhill, Justice Jack Pope, and several other highly respected leaders as its committee members.
But there's one thing I determined to do for Judge Evans, and that was carry the flag for alternate dispute resolutions. I felt that I was in a position to do that, and I felt like we were carrying the flag.
The small but effective committee was instrumental in coordinating ADR efforts on a statewide basis as additional mediation centers were being established in various cities, including Fort Worth, Dallas, San Antonio, Corpus Christi, El Paso, and Austin. The center had not foreseen the rapidly growing demand for its services that would create an almost immediate need for a public source of funds. In 1983, the Evans-chaired State Bar ADR Committee sought and obtained the support of Senator Ray Farabee, Senator Oscar Mazzei, and Representative Anita Hill for a new statewide funding statute.
In finding a public source of funding, we decided to adapt the same kind of statute that funds many court functions, like the jury fee system, and applied that concept, that user fee concept, to a filing fee method of supporting the alternative dispute resolution system.
This unique ADR funding bill was passed by a unanimous vote in both the House and the Senate and signed into law by Governor Mark White. This bill, as amended 2 years later, continues to provide public funding for some 15 local dispute resolution centers created by the commissioner courts throughout the state. After gaining permanent public funding, the Houston Dispute Resolution Center really took off in terms of the volume of ADR referrals and the expansion of its ADR services. Under the direction of a new center director, Melinda Ostermeyer, it processed several thousand civil complaints each year and extended its mediation and conciliation services to the municipal courts, justice of the peace courts, and family law courts. It also established 2 suburban satellite centers and a juvenile justice restitution program for youthful offenders. Even the Houston Police Department became engaged in this expanding effort to encourage the use of ADR methods to resolve conflicts among neighbors and families. In 1981, Victoria Shear, then director of a nonprofit organization, Concerned Teens Incorporated, developed Houston's first conflict resolution and peer mediation program at Peck Elementary School. This pioneer effort marked the beginning of an extensive conflict resolution and peer mediation program that has been expanded throughout the Houston-Harris County school system.
We went into the schools, we worked with children at all levels, elementary, middle school, and high school, and started teaching children and the students and the teachers how to approach problem solving by using mediation. And that's one area that is so important, and I think, of course, life skills have been taught to the children forever.
Impressed by the success of the Houston Bar's ADR effort, the American Bar Association's ADR Committee, on which both Professor Frankie Sander and Judge Evans then served as members, selected Houston as one of the 3 nationwide multi-door projects.
The Dispute Resolution Center would not exist without the Houston Bar Association, and one of the key people that helped and that was on the initial committee that formed the Dispute Resolution Center was Judge Evans. And so certainly without his foresight and without his time and talents, we would not be where we are today.
The Houston Center, operating under ABA's multi-door mantle, continued to expand its mediation and conciliation services in the courts, juvenile facilities, and schools.
I think the recognition of the multi-door courthouse as opposed to let's go to the courthouse was probably the pivotal point in the evolution of the ADR system, and the fact that indeed there was an alternative to litigation.
Even today, the Houston DRC continues to attract national attention for its multi-door efforts. In August of this year, it was awarded the American Bar Association's 2004 Dispute Resolution Lawyer as Problem Solver Award.
Our programs certainly are the feature of the DRC. The award sort of a nice recognition of the programs that we have. But I think it speaks well of the staff, it speaks well of the volunteer efforts that have been devoted by the attorneys who support the DRC.
Beginning in the mid-1980s, an increasing number of trial and appellate courts were beginning to appreciate the potential of using ADR as a docket control mechanism. In 1986, several Houston courts, with the encouragement and help of the Houston Bar, began experimenting with an innovative ADR process.
It's a process called moderated settlement conference. It's a way for lawyers and their clients to evaluate their cases' strengths and weaknesses.
By 1987, additional dispute resolution centers had been established in Beaumont, Louisville, and Lubbock, and more were yet to come. As the Texas legislature approached its 1987 session, its Committee on the Judiciary was considering various ADR options, including mandatory binding arbitration, as a means for reducing crowded court dockets. Due to concerns about the mandatory aspects of such legislation, Evans, on behalf of the State Bar ADR Committee, suggested that the legislature consider enacting a broad statewide ADR procedural statute that would give the courts a flexible framework for the administration of their dockets. He further suggested that the ADR procedures be voluntary in nature and promote, rather than mandate, the early settlement of pending litigation.
Judge Evans, as you all know, is the quintessential gentleman, one of the nicest people I've ever met, but with his determined leadership, we have a statute that I think created, we believe, the best model for the entire country.
Judge Evans was instrumental, I know, in writing and lobbying, writing the statute and lobbying for its passage. That certainly is one reason that ADR has flourished as quickly as it has in Texas.
Fortunately for the people of Texas, Senator Cindy Cryer of San Antonio shared the State Bar's Committee's views regarding the need for a voluntary ADR procedural system. Senator Cryer agreed to sponsor such a bill, and under her guidance, a task force was created to help draft a statute along the lines of those suggested by Judge Evans, Professor Ed Sherman, and members of the State Bar ADR Committee. With only hours left in the legislative session, Senator Cryer was able to garner the votes needed for a unanimous passage of Senate Bill 1436, which is officially known as the Texas Alternative Dispute Resolution Procedures Act.
The attention of the judiciary was drawn in Texas to the fact that mediation was available to help resolve disputes. Now, I think that one of the intents and purposes of the legislation was to do just that, to target the judiciary in this state and the attention of the judiciary in connection with ADR, and it worked.
The Texas ADR Act has become the procedural Bible for the use of ADR in civil litigation. In this act, the Texas legislature declared a broad state policy encouraging the voluntary resolution of disputes and the early settlement of pending litigation. The act directs the courts to carry out this new policy and gives them the authority to refer cases to various ADR procedures.
I think that it has been probably the greatest change and improvement in our system during my lifetime. And I've been practicing law ever since the time before we had the so-called new rules adopted back about 1940.
The Act sets out the qualifications, standards, and duties of third-party neutrals appointed by a court to facilitate an ADR process, and declares that any statement or writing involved in an ADR process is to be considered confidential and protected from discovery.
Confidentiality is sacrosanct. And because of that, we ended up in a situation in which Texas has provided leadership throughout the nation in the protection of mediation confidentiality.
Professor Hanson Lawton of South Texas College of Law, Professor Ed Sherman, Judge Evans, and Kimberly Kovac assumed responsibility for a comprehensive ADR guidebook to be distributed at the next annual Judicial Convention. Several years later, the State Bar produced an updated second edition of the handbook. Because of Judge Evans' work involving the ADR Act of 1987, Evans received the prestigious ATUR Award, which had been established by A.A. White, former dean of the University of Houston Law School, to honor individuals who had made exceptional achievements in the improvement of the justice system.
Judge Evans got the $60,000 in his hand. He could have used it for any purpose. He had a goal of sailing around the world in a boat that he was building. He could have used it for that, but he didn't. He took $30,000 of it, half, and created the A.A. White Dispute Resolution Institute, which was a 501c3 nonprofit corporation dedicated to training and research and technical assistance in ADR. He formed that institute.
For the first several years after the enactment of the ADR Act, lawyers and judges made only limited use of its provisions. However, by the early 1990s, the legal community had become more familiar with the work of the dispute resolution centers and with the various ADR systems, such as mediation and the moderated settlement conference. As the public's demand for ADR services was increasing throughout Texas, many attorneys and retired judges joined the ranks of mediators providing ADR services for compensation. A Dallas-based group, led by attorney mediator the late Steve Bruchet, chose to provide mediation services as the most viable process for resolving civil litigation.
He started the Association of Attorney Mediators. In Dallas, he was instrumental in getting the Dallas Bar litigation section to start a training program for mediation. That's where I got trained.
Thanks to Bruchet's leadership and inspiration, an active group of specially trained attorney mediators were able to develop rewarding and lucrative ADR careers. The attorney mediator concept soon spread to Houston and elsewhere in the state, and many lawyers and retired judges took the required training and began to offer their services as mediators for compensation. In 1991, Texas received a grant from the National Institute for Dispute Resolution to establish the Center for Public Policy Dispute Resolution, and Jan Sommer was named executive director.
The first thing that we did with the Center for Public Policy Dispute Resolution was to really look at the barriers to using ADR in government. What was the difference between use of the processes in the governmental arena and in a civil court?
The influx of many new mediators into the ADR profession has resulted in increasing concerns among those within the profession about the ethics of different mediation styles and practices. To diffuse this potential conflict, the State Bar ADR Committee, and later the ADR Section, sought to include both lawyers and non-lawyers and both paid and pro bono mediators in the governance process. In 1991, the ADR Section established a special task force on the quality of ADR services in Texas to create a blueprint for the emerging ADR profession.
Then the section adopts the guidelines for ethics in mediation in 1994. The section formally adopted those guidelines in April of 1994.
In 1995, the ADR Section's task force published a proposal for mediator credentialing, which would provide criteria for mediator conduct and guide the public in identifying well-trained mediators who are aware of their ethical obligations as defined by the ADR Section. About this same time, the Texas Council of Mediators, the TCM, published a very similar proposal, which recommended a multidisciplinary approach to credentialing. 2 years later, the Texas Supreme Court appointed a 25-person advisory committee on court-annexed mediation. This advisory committee drafted a consensus report to the Supreme Court.
We recommended to the court that they approve the ethical guidelines for mediation as originally approved by the ADR section and then as amended by the TMCA.
After extensive meetings, representatives of these different interests formed a multidisciplinary organization, the Texas Mediators Credentialing Association, led by ADR professionals such as Susan Duvall, Judge John Caselli, Professor Jim Gibson, and John Palmer.
We started this thing called the Texas Mediators Credentialing Association Committee, which now is the Texas Mediators Credentialing Committee, which is the credentialing body that is for everyone, for all mediators in the state of Texas. And I think that was a thing that we're very proud of, because that came out from all the work that started way back in the early 90s and culminated to where we are today at the TMCA.
The Credentialing Association is a culmination of a 14-year effort of every mediator organization in the state of Texas, led by the ADR section of the State Bar of Texas, to provide a system of standards and ethical guidelines and actually ethical rules and experience requirements for mediators in Texas. Unlike any other type of credentialing of mediators throughout the United States, this is a purely voluntary credentialing program, and it is multidisciplinary.
In response to a public invitation issued at the 2004 annual meeting of the TMCA, it has processed a substantial number of applications submitted by individuals seeking credentialed status. In 1994, South Texas College of Law trustee Rob Mossbacher conceived a plan to enhance the education of law students regarding alternative dispute resolution and professionalism.
The more we can do to create well-qualified, well-trained, well-educated peacemakers as lawyers as opposed to litigators, the better I think it will be for not only our graduates finding jobs, but also for the reputation of the school.
With the support of the dean and faculty, he established what was soon to be known as the South Texas College of Law Center for Legal Responsibility. This new center had several missions: to work with the legal community in bringing civility to the field of dispute resolution through education and training, to conduct research and advance alternative dispute resolution strategies and techniques, and to help the faculty prepare law students for their future roles as counselors with the career goal of healing disputes in the most efficient and amicable setting. The center, under the guidance of its founding director, Judge Frank G. Evans immediately initiated an action plan, which included projects in research and writing, basic mediation and family law training, employment disputes, the mediation clinic, peer mediation, and online coaching programs. With the dedication of the new Frank Evans Center for Conflict Resolution, the new center
will continue to perform and expand on some of the pro bono services, such as the online coaching program for parents and youth that the law students at South Texas have pioneered.
A recent project of the center is the International Institute for Responsible Conflict Resolution, created this year at a meeting of leading ADR professionals in San Miguel Allende, Mexico. This institute provides advanced ADR training for lawyers and business professionals engaged in international transactions. Thanks to the leadership of the center's founder, Judge Frank Evans, these projects will continue to grow and new projects will be added as the Frank Evans Center for Conflict Resolution takes root at South Texas College of Law.
Well, the center will offer a number of different new opportunities for the students. For one thing, we'll have a mediation clinic that will be run essentially by the center. We will also be offering students new curricular opportunities. We'll be encouraging our faculty to experiment with new courses in ADR, and they will be offered to the students. So we're thinking that our law school will be a leader in curricular innovations in ADR.
The history of alternative dispute resolution in Texas is a tribute to its innovative and resourceful leaders. Although these leaders fondly remember the past, they are now imagining the future.
I believe that we're going to see more ADR not only in domestic disputes, but in international disputes. And that's where the job, in my mind, really needs to be done.
I see the use of ADR in international disputes. I see the use of online ADR. I see the use of teleconferencing. I see ADR becoming DR. I see it becoming the method of resolving disputes internationally.
I think we're going to reach a point through education where dispute resolution becomes dispute resolution and not an alternative to various things. I think they're teaching the new law students to go to ADR first and to think about the courthouse later.
I think the sky's the limit. We have all the framework in place really through the early leadership of Judge Evans and others who were with him.
It's here to stay. ADR is clearly here to stay, and it's just expanding.
There was a time when people wondered whether alternative dispute resolution was a fad or a trend. I think if you ask most people today, they'd say it's clearly a trend and not a passing fad. That it is an important part of the landscape of litigation. That lawyers now today don't necessarily have to know how to be an arbitrator or a mediator, but they have to know how to represent a client in one of these alternative forums.